And this should set everything up.
And does it put the link on?
I'm going to put the link on the website.
Oh yeah, that'd
here.
be perfect.
Yeah. And this should set everything up.
And does it put the?
Stop.
I've already gotten one call about it.
Okay. I'm going to do judge halfway stream. Okay. Kind of just for the front page.
Yeah, that's fine.
So then it'll look like this when people just click on
Perfect.
that. Yeah.
So is it currently live? Like, is it playing? Or do we have to start it?
Yeah, no, it's currently live.
All right. Do you think maybe we should put it on this? Just wondering if we should put it on the screen where whoever's talking. All right. Can everybody hear me? Hands up if you're good, you can hear.
Yes, Your Honor, we can hear you.
All right, great. Thank you. All right, so we're going to go on the record. This is Planned Parenthood of Southwest Ohio Region et al. Versus the Ohio Department of Health et al. This is case number A21. I'm used to saying B. A2100870. We have several of the parties and interested persons online this morning. We are streaming this as well live, I think on YouTube on the court's website. For those who wanted to join that were concerned about COVID and coming down for today's hearing. I'm going to go around and just let everybody identify themselves before we get started. If you could keep yourself muted and then just unmute yourself and say your name and who you are, and then mute yourself again. When we start with arguments, I'm assuming that it'll just be Ms. Radiconda and Mr. Mccartney who will do the speaking. And just kind of be mindful, if I raise my hand, if you could pause, because I might have a question or there may be a technical difficulty and I can't hear you. So if you see my hand go up, just kind of keep an eye out and just take a pause and stop where you are. I'll try not to unless I really have to interrupt, but sometimes it's hard because the mics go mute when a certain person's talking, so I can't really talk over anybody or interrupt you. So I'll just do that with my hand. Okay. So I guess I've got Ms. Radiconda, I think is on my main screen here. So I'm going to go ahead and start with you, and we can just go down the line, and everyone can introduce themselves. Go ahead.
Good morning, Your Honor. Mai Radiconda on behalf of plaintiffs, and I have several co-counsel with me as well.
I'm Dr.
Fanon Rucker here on behalf of Planned Parenthood.
Okay, thank you.
Jennifer Delvin on behalf of the plaintiffs.
Thank you.
Jennifer Moore
on behalf of plaintiffs. Excuse me.
Thank you.
Jennifer Moore Conroe. I'm the executive director of Preterm, one of the plaintiffs.
Thank you.
Fred Levinson, ACLU of Ohio, on behalf of plaintiffs.
Thank you.
Chelsea Tejada on behalf of plaintiffs.
Thank you.
David Burkans, owner of Northeast Ohio Women's Center, plaintiff.
Thank you.
Morning, Your Honor. Adam Freeman on behalf of the City of Columbus.
Thank you.
Good morning, Your Honor. This is Elena Boop on behalf of Law Director of the City of Cleveland, Mark Griffin.
Thank you.
Your Honor, I'm Matt Dickinson. I'm with the Cuyahoga Falls Law Department.
Thank you.
I'm Maggie Pasqualone, Assistant Law Director with the City of Kettering, Ohio.
Thank you.
Jacqueline Martin, Assistant City Solicitor for the City of Cincinnati.
Thank you.
Connor McHugh, also with the City of Cuyahoga Falls.
Thank you.
Good morning, Your Honor. Andrew Mccartney from the Ohio Attorney General's Office. On behalf of the Ohio Department of Health, the Director of the Ohio Department of Health, and the State Medical Board of Ohio.
All right, thank you, Mr. McCartney. And just a reminder, everybody needs to keep muted. Thank you. Okay, is that everyone? Did we go through everyone?
Sorry, Your Honor. This is Julie Pfeiffer with the Ohio Attorney General's Office. I'm here on behalf of the same defendants as Mr. McCartney.
Great, thank you. Is that everyone? I think it might be. Did we get through everyone? Okay. All right. Speak now or forever hold your peace, I suppose. Okay. I think we got everyone. Okay. Oh, I'm sorry. Go ahead.
This is Denise Rini along with Andrew McCartney for the Ohio Department of Health.
All right. Thank you. Okay. All right. So we are here, this is the plaintiff's second motion for preliminary injunction of the parties. I'm specifically speaking to Ms. Radiconda and Mr. McCartney. Are you all ready to proceed to argument today?
I am, Your Honor.
Yes, Your Honor.
All right, then I will, let's go ahead and proceed. Ms. Radiconda, you may begin.
Thank you, Your Honor. SB 27 singles out procedural abortion and treats it differently from any other medical procedure. It imposes requirements that are more burdensome and onerous than those imposed on the disposal of tissue from miscarriage management, and in fact, more onerous than those imposed on the disposal of human remains. Plaintiffs' evidence shows that SB 27 would result in devastating harms on plaintiffs and their patients. I know the court is familiar with our briefing, so I won't go through all of the specifics, but I do want to remind the court of some of the evidence we submitted, because it's striking that the state submitted none. SB 27 will act as a ban on procedural abortion until around 13 weeks of pregnancy, and a ban on all abortion between 10 and 13 weeks. This is because abortion providers risk violating either SB 27 or laws regulating infectious waste if they can't separate embryonic and fetal tissue from other pregnancy tissue early in pregnancy. Plaintiffs' patients will be significantly delayed in obtaining procedural abortions, including because providers will be prevented from performing them until around 13 weeks, and because of the substantial increase in the price of the procedure. As our medical expert, Dr. Leiner, who has extensive experience in reproductive health care, has explained, delays like this can increase health risks. Delays can also force patients into a vicious cycle where they're unable to afford the procedure and are delayed to a point later in pregnancy when the procedure becomes even more expensive. The majority of abortion patients are poor or have low incomes. Dr. Norwood, an expert on poverty and access to reproductive health care, submitted compelling testimony on the sacrifices that patients will have to make to meet the increased costs. These include not paying rent or utilities, reducing food budgets for themselves and their families, or being forced to turn to predatory lenders. And as the providers and Dr. Norwood explained, some patients will simply not be able to afford to have an abortion if SB 27 is in effect, and they may have to carry their pregnancies to term and give birth against their will. Patients and providers will also be seriously harmed by having to acknowledge that tissue from procedural abortion will be treated like human remains, and thereby having the state impose on them its belief on when life begins. Reverend Terry Williams testified that this is a belief that many don't share, and that SB 27 will impose trauma, guilt, shame, and anger, resulting in significant mental and spiritual harm. State defendants don't offer any evidence to dispute the extensive evidence of harm that plaintiffs have submitted. While they claim that some harm is mitigated because plaintiffs may not need to separate embryonic and fetal tissue from other pregnancy tissue, this is unsupported, as I'll later explain, and SB 27 would remain extremely burdensome even under defendants' interpretation. Instead, state defendants offer some weak justifications for the law in urging this court to uphold it, but they come nowhere close to meeting the standards that apply to plaintiffs' claims. As this court has previously held, regulations that burden access to abortion are subject to the highest level of scrutiny under the Ohio Constitution. This is supported not only by Ohio precedent that recognizes a fundamental right to privacy, procreation, bodily integrity, and bodily autonomy, but also by the textual differences in the Ohio and federal constitutions. SB 27 doesn't survive strict scrutiny under both plaintiffs' due process and equal protection claims. And in fact, state defendants make no arguments to justify SB 27 under strict scrutiny review, despite that the burden falls on them to do so. SB 27 can't advance any compelling interest in, quote, proper disposal of tissue or disposal in a, quote, dignified manner. State defendants haven't submitted any evidence that this requirement is necessary from a public health perspective, and they don't dispute that incineration, which is how plaintiffs currently dispose of tissue, is generally the same process as cremation, despite cremation being significantly more expensive, or that the medical waste disposal requirements that plaintiffs currently follow will still apply to tissue from other medical procedures under SB 27, including identical tissue from miscarriage management. And any state interest in disposing of tissue in a quote dignified manner just can't account for why SB 27's requirements are more restrictive than those that regulate disposal of human remains. SB 27 also doesn't increase patient choice in any way. It actually does the opposite by limiting disposal options. Plaintiffs are likely to succeed even under a lower standard of review. As to plaintiffs' due process claim, even if this court doesn't apply strict scrutiny, the federal undue burden standard must apply. And state defendants' arguments that rational basis review applies just make no sense. It's clear that SB 27 regulates abortion, both from the face of the statute, which applies to abortion providers and patients, and also from plaintiffs' extensive evidence of the law's effect on abortion access. Under the federal undue burden standard, SB 27 is unconstitutional because it provides no benefits, and instead it imposes severe burdens, some of which I've already talked about. The law also violates plaintiffs and their patients' equal protection rights because there's just no justification for imposing more onerous requirements on providers who perform and patients who get procedural abortions than those imposed on those who obtain or perform other medical procedures, such as miscarriage management or in vitro fertilization, or even on the disposal of human remains. And in fact, SB 27 would fail even rational basis review for this reason. This court should also continue to enjoin defendants from enforcing SB 27 for the additional reason that the law and its implementing rules are unconstitutionally vague. Plaintiffs have asked ODH to provide clarity on the very issues they raise in this litigation for months, and ODH just refused to do so. And state defendants suddenly claim now that the law is, quote, clear, but their reasoning lacks support, including in the very wording of the statute and its implementing rules. And plaintiffs are not required to accept state defendants' mid-litigation position. Instead, this court would have to make an explicit finding, for example, that the law is clear that it does not require embryonic or fetal tissue to be separated from other pregnancy tissue. And in any case, any such finding would not sufficiently mitigate the significant burdens of this law, including a substantial increase in cost that will delay or prevent patients from obtaining care, providers being forced to enter into precarious agreements with the few vendors willing to partner with them, and the providers and patients being targeted for stigma and shame for their choice in healthcare. Finally, state defendants claim that plaintiffs don't have standing to bring claims on behalf of their patients, and that the constitutional provisions under which plaintiffs seek relief are not self-executing. But a long line of precedent supports plaintiffs' ability to bring claims on behalf of their patients. And plaintiffs' due process and equal protection claims are proper, both because they're brought under the Declaratory Judgment Act and because the constitutional provisions are sufficiently precise, and therefore they're self-executing. This court has already actually addressed these issues in both this case and the case challenging the telemedicine abortion ban. So, Your Honor, without relief from this court, plaintiffs will have to come into compliance with SB 27 on February 8th, or they have to stop providing procedural abortions. And in fact, plaintiffs' patients will be affected well before February 8th, including because of Ohio's mandatory delay law and the delays in patient scheduling. So plaintiffs respectfully ask this court to rule on their motion quickly so that plaintiffs can continue providing and patients can continue accessing essential health care without being burdened by SB 27's onerous requirements and the delay, expense, and stigma that they would impose. Thank you, Your Honor.
Thank you. Go ahead and let Mr. McCartney respond, and then I have a few questions. So go ahead, Mr. McCartney.
Thank you, Your Honor. Again, this is Andrew McCartney representing the Ohio Department of Health and its director and the State Medical Board of Ohio. The state of Ohio has valid interests in promoting the dignity of unborn human life by, in the words of Justice Clarence Thomas in the Box case, quote, prohibiting abortion providers from treating the bodies of aborted children as infectious waste and incinerating them alongside used needles, laboratory animal carcasses, and surgical byproducts. In the 2019 Box v. Planned Parenthood of Indiana and Kentucky case, the United States Supreme Court held that, quote, "A state has a legitimate interest in proper disposal of fetal remains," unquote. SB 27 ensures the humane treatment of fetal remains, and the clinics have a heavy burden to show that such a decent and humane law runs afoul of any constitutional requirement. It is the clinic's burden to show entitlement to a preliminary injunction by clear and convincing evidence. None of the clinic's arguments do so. As an initial matter, the state defendants will rest on their briefing on the standing and cause of action arguments that Ms. Radiconda addressed at the very end of her opening argument, unless Your Honor has questions on those points.
I do not. I guess I'm looking to hear more about these the rules that were promulgated now that we're beyond that, because I think that was the issue before, that the rules weren't yet promulgated, so there really wasn't a way to comply with this law. But now that they're promulgated, that's kind of where I'm looking for the argument there.
Great, sure, Your Honor, and that's correct. The rules are now available, and the implementing rules pursuant to the statute are now available. So the first round and the original complaint was, as you said, focused on sort of a clarity issue, and that was the first round of briefing and the first iteration of this lawsuit. This is now the clinic's attempt to substantively challenge the statute itself and its provisions, and then the rules that are released pursuant to that statute. And just a quick note there, Your Honor, really the clinic's problems are with the statute that the people of Ohio's elected representatives have put forth. The rules implementing that don't have the authority to rewrite the statute or go beyond what the statute itself provides. So those rules are now available, but what those rules do is simply implement the plain text of the statute itself. On the substantive challenge and the points that Ms. Radiconda raised just now, I want to focus particularly on irreparable harm. I'll briefly cover the constitutional arguments substantively as well, but I'd like to start with irreparable harm because if the clinics can't meet by clear and convincing evidence their burden to show irreparable harm, they can't carry their burden for entitlement to a preliminary injunction. And the clinic's briefing is tellingly short on irreparable harm. And this is for a couple reasons. The first one is that SB 27, as we argue throughout our briefing, it's not a abortion regulation. It's not a classic attempt to regulate the abortion procedure or the procedures surrounding the act of abortion. It governs the disposition of fetal remains after an abortion has taken place. What that means practically is that this is a case about cost. And cost is not irreparable harm under the case law. And the clinics don't argue that the costs that they might have to pay that are increased from what was the case before SB 27 constitute irreparable harm. That really leaves the clinics to just make the point that there are constitutional injuries. Of course, we dispute that, but there are a couple key points on the clinic's evidence. First, on the issue of the burden, Ms. Radiconda stated several times that the state put forth no evidence, but of course it's not the state's burden to put forth evidence to show by clear and convincing evidence that the clinics are wrong. It's the clinic's burden by clear and convincing evidence to show that the state's law is unconstitutional. What the clinic's evidence actually shows is notable, and Ms. Radiconda didn't go through this in her argument, but I'd like to just briefly highlight a few points. So one, the clinics have found several vendors for both cremation and interment that together can meet all the clinic's projected needs. Two, these costs could be as low as $75 for individual interment and $95 for individual cremation. That's the Bertulite affidavit, paragraph 15. 3, while Ms. Radiconda asserted and the briefing asserts that cost increases to patients will be, quote, substantial, of course, that assertion is not evidence. There is no evidence that these vaguely alleged costs must be passed on to patients. There's no evidence that the clinics are unable to mitigate costs for those patients with fewer financial resources. And there is no evidence that whatever costs might be passed on to patients will result in those patients being unable to access surgical abortion. 4th, and this is important for the legal standard as well as the factual evidence, any costs that the clinics might choose to pass on to patients would have a downstream effect only on surgical abortions, not medication abortions. This is undisputed. What this means under the case law is that SB 27, even if viewed as a state regulation of abortion, cannot be an undue burden on patients. At the very end of her argument today, Ms. Radiconda, if I understood correctly, made the sweeping statement that SB 27 will force the clinics to stop all abortions. That's not quite right, I think, for a couple reasons. First, I think the most the clinics can allege and have alleged in their papers is that because of the clinic's alleged concern about whether they can distinguish fetal tissue from other tissue, they might not be able to, out of an abundance of caution, perform surgical abortions between 10 weeks LMP and 13 weeks LMP. Medication abortions are available through 10 weeks LMP, and the clinic's evidence shows that they perform surgical abortions, quote, up to maximum gestations between 16 weeks and 6 days LMP and 21 weeks and 6 days LMP. That's page 3 of the clinic's opening motion. So what that means is that at most, what the clinics have alleged is a 3-week delay in performing surgical abortions. And under the case law, a 3-week delay, even if that results in some increased costs, is not an undue burden. This gets to Ms. Radiconda's argument throughout and plaintiff's argument throughout in the briefing that strict scrutiny would apply. And the clinics really feel the need to stick with that standard as the only way, I think, that they could potentially succeed. Now, strict scrutiny might have some purchase half a century ago in 1972, but it really can't in 2022, 50 years later. The reason for that is we now have decades of abortion jurisprudence making clear that if a statute is viewed as a direct regulation of abortion, then the undue burden standard would apply. And we go into that standard at length in our briefs and show why, under the applicable case law, states do have legitimate interests, of course, Bach says, in the fetal remains disposal, but also states have strong interests in promoting respect and regulating the medical profession to promote respect for human life, including the life of the unborn. That's the Gonzalez v. Carhart case from the US Supreme Court in 2007. So there's really no circumstance in which strict scrutiny could apply here. We argue that rational basis review applies under Bach's. SB 27 is clearly constitutional, but even if a more rigorous standard would apply, that standard would be the undue burden standard. And for the reasons that we state in our brief and that I've just stated, again, states have strong interests in promoting respect for human life. SB 27 is constitutional as well. What the clinics have in the evidence affidavits that they've presented is really a long string of mights and maybes. The clinics might have to pass on some costs to patients. The clinics might not be able to mitigate those passed on costs for patients with fewer financial resources. Some patients with fewer financial resources might not be able to pay for a surgical abortion. And some of those patients who might not be able to pay for a surgical abortion also might be too far along to obtain medication abortions. This string of hypotheticals is far short of clear and convincing evidence. Abortions have always had a cost. It is the clinic's responsibility to ensure they can still operate their business while also complying with the state's law ensuring the humane treatment of fetal remains. Finally, as to unconstitutional vagueness, the clinic's final argument, the clinics here miss a fundamental principle, and Ms. Radaconda didn't refer to this principle in her argument today, that states' laws are presumed constitutional and must be interpreted so as to avoid striking them down as unconstitutionally vague, if at all possible. No law is perfect and no law addresses every contingency. As the Ohio Supreme Court has held, quote, the challenging party must show that a statute is vague, not in the sense that it requires a person to conform his conduct to an imprecise but comprehensible normative standard, but rather in the sense that no standard of conduct is specified at all, unquote. That's State v. Anderson from 1991. On each of the 3 points of potential vagueness that the clinics argue in their brief, the clinics can't meet that heavy burden. And regardless of which vagueness test this court applies, SB 27 is constitutional. On simultaneous cremation, just 3 quick points. Ohio law generally prohibits simultaneous cremation. SB 27 does not change this, and the clinic's papers agree. 2, one of the clinic's own affidavits correctly reads SB 27, stating, quote, simultaneous cremation is not permitted, unquote. Lee Masters affidavit, paragraph 21. 3, SB 27's purpose of honoring the unborn and protecting the dignity of human life confirm this, because SB 27 parallels the treatment of adult fetal remains, which are not generally permitted to be simultaneously cremated. And then 4, the textual emphasis throughout the statute is on individual treatment of aborted fetuses, not simultaneous treatment. Second, the point about sending tissue of aborted fetuses to third parties. Here, I think the clinics confuse silence on a separate issue with ambiguity or vagueness. So SB 27 clearly defines fetal remains as, quote, the product of human conception that has been aborted. The clinics must cover the cost of the final disposition of such remains by cremation or interment. SB 27 doesn't prohibit sending the tissue of aborted fetuses to third parties. That's a separate issue, but it's not one that the statute creates ambiguity on or says in one place that the clinics can do it and in another place that the clinics can't do it, which is what we'd be looking for ambiguity. And finally, as to what fetal remains means, again, I just quoted the statute there, the product of human conception that has been aborted. This would include anything that is the product, such as placenta, gestational sac, and umbilical cord. Again, I think what the clinics are really looking for and hoping for here is affirmative assurances, but that's not part of the constitutional vagueness analysis. The constitutional vagueness analysis is on the text and on whether the text is clear as to a comprehensible, if not completely precise standard. And again, no law is perfect. No law has to address every contingency to be constitutional. For these reasons, the state defendants respectfully request that this court deny the clinic's second motion for a preliminary injunction, focusing particularly on the fact that clinics have not met their burden to show irreparable harm. Unless your honor has any questions, the state defendants will rest on their briefing as to any remaining points.
I do actually have a couple questions. Okay. I think something you just recently mentioned in your argument that I guess is the state conceding that the plaintiffs could send remains to a third party under this law without being in violation?
What the state defendants have said in their briefing, your honor, is that the statute does not prohibit, just as a textual matter, the statute does not prohibit sending tissue to third parties. It simply doesn't say one way or the other that that's impermissible. All it requires is that the clinics cover the cost of the final disposition. The clinics don't even have to perform the cremation or interment. Obviously, they're looking at contracting that out. All that the statute requires is that the clinics make sure that they do, in fact, cover the cost of cremation or interment for the final disposition of those fetal remains.
So I guess what you're saying is, in order to be compliant, the plaintiffs would have to, let's say they send it to a lab for testing. If there's a criminal allegation involved, they send the tissue to the lab for testing. They have to make sure that either that third party does what they're required to do, or they get the remains back so they can do it. I mean, is that really what the law is requiring? You're saying it's not vague. I mean, I guess you're saying it's a little vague, but I guess I want some clarity on that issue.
Sure. And Your Honor, that's where I would draw a distinction between sort of a separate issue on which the statute is silent versus a constitutional vagueness or ambiguity. So the statute doesn't create conflicting obligations for the clinics there. If the clinics have a way in the details of this to ensure that tissue that they've sent that is fetal tissue, and the clinics don't make clear exactly what tissue we're talking about, but if it is fetal tissue that's being sent to, say, a crime lab, yes, the clinics will need to make sure that they partner with that separate third party so that that fetal tissue is treated the same way that adult human remains would be treated at the end of the process. Again, the clinics don't have to do that themselves, so this might be a three-way, the clinics working with the crime lab, working with the clinic's chosen vendor for cremation or interment. But again, the statute simply requires the simple duty that the clinics cover the cost of that. The fact that the statute doesn't go into details of that three-part arrangement and exactly how that would work doesn't render it unconstitutionally vague or ambiguous.
All right. You mentioned this also in your, well, I'll go with this one first, because you mentioned in your argument that I have another question, but I think you said that, I guess, not being able to perform the procedure between 10 and 13 weeks, you said that wasn't, I guess you called it a delay. You didn't call it a prohibition, but I guess what I'm asking is how is having to wait that 3-week period, how does that not create an undue burden?
Right, sure, Your Honor. So under the case law, and we cite a case from, I believe, 1990 from the U.S. Supreme Court that specifically dealt with a 3-week delay in the parental consent context. The law involved some kind of required parental consent, and there was a specific 3-week delay at issue, and that was not treated as a cognizable undue burden. So the delay itself, for one type of abortive procedure, under the case law, it's pretty clear that that doesn't constitute a substantial obstacle for a couple of reasons, that I mentioned. There's still the medication abortions, which are untouched by the statute, that can be performed through 10 weeks LMP. And then, this isn't a case where Ohio law prohibits the clinics from performing surgical abortions, say like after 11 weeks. The clinics perform surgical abortions up to almost 17 weeks or up to almost 22 weeks. So even if the clinics, out of an abundance of caution, say we don't want to perform surgical abortions between 10 and 13 weeks, that 3-week delay for surgical abortions only isn't an undue burden legally, just as a matter of law.
Okay. I guess something that you said actually leads me to my next question. So when we're talking about the medical, or I should say the telemedicine abortion and the ability to get medications for an abortion, how are the remains from medicated abortion different from the remains of a surgical abortion? Because you're telling me, I think you've said over and over again, this is the purpose of this statute is to preserve the dignity of the unborn life. But we have two, I think, identical remains, but one requires compliance with this statute and the other one does not. So how do you justify that?
Sure, Your Honor. So a couple points. One, I mean, just as a full disclosure, I'm not a medical expert, but I think the constitutional principle that would be key here is that a state doesn't have to do everything at once. So the state of Ohio can constitutionally seek to promote the respect and the dignity of human life and unborn human life in this case by regulating a particular area. Whether the state might eventually want to regulate additional areas to continue furthering that interest, that could be something down the road that the state could constitutionally do, but it doesn't have to do everything at once. And part of this is just the practical nature. Again, not being a medical expert, but my understanding is that it would be pretty difficult just on a practical level to require the treatment of fetal remains in medication abortions to be identical to cremation or interment, just practically. So again, there's the practical considerations, and then two, just as a constitutional matter, the state can regulate a piece at a time. It doesn't have to do everything at once in its furtherance of human dignity and human life.
And I guess just for clarity, is the state conceding that this creates an issue where there is that delay between 10 and 13 weeks, the way this statute is written, because the law is not clear on whether or not the tissue needs to be separated, that does kind of put a pause on the ability to get access to abortion between 10 and 13 weeks?
No, Your Honor, and thank you for that clarifying question. The state is not conceding that a 3-week delay is created. What the state defendants are saying is that even assuming for the sake of argument that there is a 3-week delay, that's sort of the most that the clinics have alleged. So sticking with that, even that is not a constitutional undue burden under the case law. But there are a couple problems with the 3-week delay argument. One is just that it's not something that SB 27 as a textual matter actually requires. The 3-week delay arises from the clinic's asserted concern that they won't be able to distinguish between fetal tissue and other tissue in surgical abortions until 13 weeks LMP or after 13 weeks LMP. Now, in our vagueness section of our briefing, we make clear that the statute defines fetal remains as the product of human conception that has been aborted. And the clinics themselves acknowledge that SB 27 it's a sea change in that it now says fetal remains are no longer to be treated as infectious waste. And that has, a set of criterion of what is infectious waste and how is that treated. Fetal remains are no longer infectious waste. And so with that distinction, anything that's the product of human conception, such as the placenta, as we talk about in our briefings, that's no longer to be treated as infectious waste. So SB 27 is a change in the law. It doesn't create ambiguity. So we would dispute the clinic's assertion that they'll have to stop providing surgical abortions because of confusion, because the statute itself doesn't create that confusion. That's a self-imposed confusion on the clinic's part. That said, even assuming for the sake of argument that there is a 3-week delay, that itself is not enough under the law.
Just one quick question. Something you just said just struck me. So did you say that under Senate Bill 27, they're considering like the placenta to be the fetal remains?
The concern, Your Honor, as I understand it from the clinic's perspective, is whether the placenta, for instance, or the umbilical cord is to be treated as infectious waste or is to be treated as fetal remains. Under the definitions of the statute, it's pretty clear that that would fall under fetal remains, not infectious waste. That's where SB 27 makes a sea change. Fetal remains are no longer to be treated as infectious waste.
Well, let me ask you this. If somebody delivers a baby and there's a placenta, a hospital would generally treat that as infectious waste. They wouldn't be required to go and cremate or bury the placenta. Am I correct in that? Like if somebody carries a baby to term and delivers the baby along with the placenta, they wouldn't be required, I think under the current law, they could treat that placenta as infectious waste and it could be disposed of accordingly. They wouldn't be required to follow this Senate Bill 27 and either bury or cremate that placenta.
Well, and Your Honor, I think that goes along with the current legal regime prior to SB 27, which is that, yes, that would have been infectious waste. But SB 27 now says the product of human conception that has been aborted counts as not infectious waste, but as fetal remains, and is to be treated similarly to the way that we treat adult human remains.
Okay, all right, thank you. Those are all the questions I have for now. I'm going to go ahead and give Ms. Radiconda one more opportunity to argue since it's her motion. And then I may have a couple more questions and then we'll adjourn. Go ahead, Ms. Radiconda.
Thank you, Your Honor. Just a few points that I want to raise in response. First, just to point out again that state defendants, again, don't try to justify SB 27 under the strict scrutiny standard. And in fact, the burden is on them to do so under strict scrutiny. So the fact that they don't address this at all is quite striking. State defendants do rely on the Box case. And I just want to point out that in that case, the Supreme Court applied rational basis review after repeatedly stating that the providers, the plaintiffs in that case, did not raise substantive due process claims on behalf of their patients. Obviously, that's not the case here. We do raise substantive due process claims, and so rational basis review simply can't apply here. The state defendants also question the evidence that we have in the record regarding irreparable harm and seem to say that all of the harms that we have submitted evidence on are compensable harms, and that's simply not true. We have extensive evidence in the record, evidence that the state defendants have not disputed with their own evidence, and this evidence includes statements by fact and expert witnesses showing that patients will be significantly delayed in obtaining care, increasing risks to their health. Patients will be prevented from obtaining abortions entirely, will be forced to give birth against their will. This is simply not compensable harm. And then the state defendants also raise issues regarding the cost increases. They say that these are vaguely alleged, but in our evidence, we have submitted precise evidence regarding the cost increases, including the cost related to the interment and cremation itself, and which range from $75 to $295 per product of conception. And there are, of course, also harms or cost increases related to the delay that patients will experience from this law. And there's evidence, for example, from the two Planned Parenthood provider entities stating that the price of an abortion increases by $150 if patients are delayed past 13 weeks of pregnancy. So there are precise cost increases that we have included here. And of course, these increases will have to be borne by the patients, while the providers will be contracting with crematory and funeral director vendors and paying those vendors for the cremation and interment services that they're providing. This can result in up to hundreds of thousands of dollars for the providers. And of course, this will result in an increase in the price of abortion that the patients will have to bear. The state defendants also state that this law only has an effect on procedural abortions, which is true, but procedural abortions are the only method of abortion after 10 weeks of pregnancy in Ohio. And we have also submitted evidence of patients who will need to have a procedural abortion even before 10 weeks of pregnancy, even when medication abortion is available. This includes patients for whom they have a strong preference for procedural abortions for various reasons, including the fact that procedural abortion may be safer because they can't have a medication abortion and then pass the pregnancy in their home if they are in an abusive relationship or they have a parent or others in their household that they can't let find out about the fact that they're having an abortion. So certainly a vast number of patients will be affected by this. And state defendants, again, state that strict scrutiny simply doesn't apply, but they really don't address any of plaintiffs' arguments as to why strict scrutiny applies, and certainly don't address the this court's previous ruling on this issue. And as we have stated, Your Honor, we win even if a lower standard of review would apply to our claims. The state defendants also state that regarding simultaneous cremation, they don't properly explain why the fact that the law requires patients to fill out and providers to fill out different forms for each embryo or fetus necessarily means that each embryo or fetus has to be cremated individually. And they also, regarding the pathology and crime labs, I honestly am still confused as to their exact position on this issue. As we have addressed, the issue is whether the providers would be liable if we send tissue to a third party, such as a pathology or a crime lab, and whether we would be held liable if that third party does not cremate or inter the tissue in accordance with SB 27. And as we have put in the record, pathology labs, our providers contract with pathology labs that are located outside of the state, simply cannot ensure that those third parties will be cremating and interring tissue in accordance with SB 27 for that reason alone. Again, state defendants raised some claims regarding the vagueness issue with the separation. And I'm, again, still confused as to exactly where they land on this issue. And we certainly, in light of this confusion, we certainly can't take their mid-litigation position in order to conform our providers' conduct. And instead, this court would have to make explicit findings regarding separation in order for our providers to be able to proceed with not separating the tissue early in pregnancy. And finally, Your Honor, state defendants claim that the burdens that we have alleged, including up to weeks of delay for our patients, are simply not sufficient under the case law. But that is not the case. The one case that state defendants cite in support of this from 1990 states that up to 3 weeks of delay may be possible. But here we are showing that at least 3 weeks of delay will be the case for the vast majority of our patients the vast majority obtain abortions early in pregnancy. So it is a certainty that our patients will be delayed for a significant amount of time. And moreover, recent case law from the Supreme Court, including June Medical Services and Whole Women's Health, have recognized that delays, longer wait times, are cognizable burdens when they've struck down abortion restrictions. Unless this court has any further questions, I'm happy to answer those.
I actually do have a couple questions. So we talk about this 10 to 13 week window where I think the state's calling it a delay, you're calling it a denial of access. How many people generally, I don't know, I don't remember reading this in any of the affidavits necessarily that I reviewed. What is the percentage of people that seek that procedure during that window of time?
We don't have evidence in the record, Your Honor, on exactly how many patients seek procedural abortions during that time, but there is evidence in the record that the vast majority of patients seek abortions prior to 13 weeks of pregnancy, so in the first trimester of pregnancy.
And also I had a question more specific to, because I think there was a lot of talk about the rules in the previous preliminary injunction, and specifically the forms that were required to be executed. Are those forms prepared? Do we know what information is being requested and what information may be delivered to the crematory or the place of internment? What information they're providing on those forms to those third parties?
Yes, Your Honor. So the 1 business day before the law, the rules were to be made effective, defendant ODH sent the forms to our clients. And so we were able to review the forms at that late stage. And the forms do seem to somewhat mirror the rules in terms of what they require. And they certainly don't clear up any of the ambiguities that we have raised in this litigation and that we have raised previously with ODH when we've asked them to address various ambiguities in the law in either the rules or the forms. Neither the rules or the forms address those ambiguities.
And let me ask you this, is there identifying information of the patient required on the forms?
Are you asking specifically, Your Honor, the form that would be given to the crematory operator? No, my understanding is that the patient name is not required to be on that form. Instead, there's a patient medical identification number that would need to be included on that form, and a physician signature would be required, but not a patient signature.
All right, thank you. All right, those are all the questions that I have. I know that we're on a deadline here, a somewhat tight one. So I will have a decision out before the 8th, which I think is the deadline that we're looking at right now, February 8th. Is that correct?
Yes, Your Honor. February 8th is the deadline. And I just want to state one more time, Your Honor, that because of the mandatory delay law and delays in patient scheduling, patients will start to be impacted before that date as well.
All right. I don't think we need to set a hearing for decision. I think I could just put on an entry. I'm going to get it done as soon as I possibly can. It will be done before the 8th. I'll guarantee you that. Is there anything else that we need to address before we adjourn?
I just have one issue, Your Honor. I know that we have a case management conference set in this case for this coming Wednesday. Mr. Mccartney and I have not had a chance to speak about that, but in light of this hearing and a pending decision, perhaps it makes sense to postpone that for a short time.
Is there a date that you all specifically are looking at to reschedule the CMC? Because we could probably go ahead and do that now if you have your calendars in front of you.
I can certainly look. Mr. Mccartney and I have not spoken about this beforehand, so but I can take a look. I'm out of the office the week of the 7th, but I'm here after that at your convenience.
Mr. McCartney, I guess would that be then the week of the 14th? Would be the 5th. Does that work for you, Mr. McCartney?
Yes, Your Honor. The week of February 14th would work for me, and I agree with Ms. Radicana. It would be helpful to push that out just a little bit.
Okay, great.
Do the 15th at 1:30 p.m.
How does the 15th at 1:30 work?
That works for me, Your Honor.
And same for me, Your Honor.
Okay, great. So we'll push out that CMC to February 15th at 1:30. And that, I think we'll just do that on the phone. Is there anything else that we need to address before we adjourn?
Nothing from you, Your Honor.
For me, Your Honor.
Great. All right. Thank you. I thank you all for your patience, your participation, your argument. I will get that decision out as soon as possible. And then we'll talk to you all on the 15th.
Thank you.
Thank you.